Alright, so today we will be talking about legal compliance, I Choose You, and we'll be examining augmented reality issues through the lens of Pokémon GO. And one final housekeeping tip before we get started. This program, if you can notice right there, we have a 360-degree camera, and it is being recorded using the ALLie camera. And it will be uploaded to YouTube pending approvals afterwards. And we will be definitely excited to share that. And from all my research, basically searching on YouTube, I could not find any other CLEs that have ever been recorded or uploaded that have been recorded in 360. So you're part of a new experience today. And so 360 camera essentially means, as you can see, there's a camera on the front and on the back. As you watch it, you can turn and view anywhere in the room at any time. So people on the front row, we just wanted to let you know you also can be seen. More further on back, probably not going to be able to see you. So ALLie, we thank ALLie Camera for providing the camera, and we're really excited about that. Alright, so our panel today, we have Chrissy Stelsey. She is U.S. General Counsel for Wargaming, an award-winning online game developer and publisher that is a leader in the free-to-play MMO market across PC, console, and mobile platforms. She is responsible for legal and business matters for the company's operations in the United States, including copyright, trademark, advertising, privacy, compliance, esports, inbound and outbound licensing events, and basically any question involving what can be done with a tank. And she has an amazing outfit today, if you want to come up and see her later. Or it's a model. No. There we go. So prior to joining Wargaming, Ms. Stelsey practiced entertainment and new media law and was in-house counsel for a serious games company. She has served as an editor of the book Computer Games of Virtual Worlds, A New Frontier in Intellectual Property Law, which is published by the ABA section of Intellectual Property Law and is a chapter contributor to the ABA's Legal Guide to Video Game Development. Ms. Stelsey received her BBA in Marketing from Loyola University, New Orleans, a JD from St. Louis University School of Law, and an LLM in Entertainment and Media Law from Southwestern Law School. If I'm correct, you were the first class that did the online program there.
Correct. Yeah.
Great. So a little plug for Southwestern and Marriott. John Polito is one of our other panelists. He is an IP partner in the San Francisco office of Morgan Lewis. John's practice focuses on software license disputes and copyright litigation. His team's most recent trial wins include a substantial copyright infringement and computer fraud jury verdict on behalf of Oracle and the defeat of a $1 billion transfer pricing claim that the IRS had brought against Amazon. John also handles authorship disputes, technical investigations, and copyright registration and counseling. His pro bono efforts focus on civil rights and immigration issues. John holds a Bachelor of Music in Music Performance and Composition and a BA in Mathematics from the University of Michigan and a JD from Stanford University Law School. He is also a publisher for the ABA. He was published the ABA-IPL 101 Practice Series, Copyright Jurisdiction, and Reed, Elsevier, and Muchnick in 2010. Kimberly Culp is a litigation attorney in Venable's San Francisco office. She practices largely in the digital media and gaming space. Her litigation practice includes pre-litigation risk management on intellectual property, advertising, trade secrets, and general business matters. Kimberly holds a BA in history from UC Davis and a JD from UC Hastings. Jimmy Yoon is an associate general counsel at Oculus. Prior to joining Oculus, Jimmy spent time in private practice and also served as senior legal counsel at Samsung Electronics for their device solutions businesses. Jimmy holds a BA in political science from Dickinson College and a JD from Temple University. And a quick disclaimer, the statements and views expressed throughout this presentation by each of the panelists and myself, the moderator, are her or his own and do not reflect those of the employer or law firm of any of the panelists or moderator. And also trademark disclaimer, I'll let you read that. I'm not going to read it out loud because we are all attorneys. Alright, so let's take a look at what we'll be covering today. We'll start with an overview of augmented reality and limited technologies, as well as a massively successful Pokémon GO game. Then we'll dive deeper into the legal issues video game developers encounter, starting with an examination of end-user license agreements, terms of services, and privacy policies. Moving next into trademark and copyright issues, and closing out with towards trade secrets and other claims. And we will have time for questions at the end. So for today's presentation, there are some basic definitions to understand. Augmented reality, virtual reality, and virtual worlds are the three categorical distinctions. And here within the ABA section of intellectual property law, we actually have a committee or subcommittee that addresses each one of these categories. And so I highly encourage you, if you want to get more involved and learn more about these, definitely go to the ABA section's website and check out those committees and get involved. For a cursory overview today of all of them, augmented reality is when a live or a real-world view is taken and augmented or supplemented with computer-generated content. And examples include Pokémon GO, or as simple as a Snapchat filter. Virtual reality, as pictured in the image on the slide, the one with the woman holding the headset, is when a virtual or digital environment is simulated by the use of a headset. And examples of these include the Oculus Rift or the Samsung Gear VR. Virtual worlds, or MMOWs, are computer-generated environments or worlds that are populated by users who may use like an avatar to represent themselves digitally as they travel around and explore the world. All right, John, do you want to take us into a deeper dive and explain further?
Sure. There's a lot of computer science about virtual reality, augmented reality, and other aspects of the merging of virtuality and reality, and we're not going to talk about any of them, except briefly to say most computer scientists think of it as a continuum, where most of us live most of our lives right now in the real world. Virtual reality, think of it as the real world has been replaced, right? So you are in the virtual universe. Augmented reality is kind of close to the real world, if we can say that. So it might be that there are simple virtual objects that are overlaid in your universe. There are, in the computer science field, sometimes we'll talk about augmented virtuality or mixed reality, when you start to have virtual objects that act a lot like their real world counterparts, or when you have a primarily virtual world and you start putting real objects into them. So if I can step into the virtual world, it's no longer a pure virtual reality environment if you see me and see me acting in real time. Next slide. So here's an example of a very simple augmented reality app other than Pokémon GO. Here's a virtual image of the Mars space rover, and next to it an actual model of the Mars space rover. So this is a NASA app called NASA Spacecraft, where you can take virtual spacecraft and put them into the real world, and they will do things like stay on the floor. And sometimes, not always, they will not run into objects. That's kind of a basic start for what an augmented reality application can be. More commonly, when you think about a set of attributes that augmented reality applications might have, remember, these are applications that are based primarily in the real world with some virtual objects. Typically, you want to have an application that can sense the properties of those virtual objects and provide you, the user, some feedback about it, whether it's visual, sound, haptic feedback, other kinds of feedback. Most augmented reality applications that you're going to use are going to be in real time. Anything from Google Glass, maybe showing you data, to something that is giving you a telemedicine prompt where you can interact virtually with data in front of you, even though you know you're seeing a real world image as well. Many, but not all, augmented reality applications also involve the tracking of real world objects in the same way that you track virtual world objects. And one of the applications that probably everyone in this room has already heard of, one of the reasons that we're here today is to talk about Pokémon GO. Next slide, which is, for people who haven't seen it, we'll have a slide that as they say on the Virgin America, for the 0.001% of you who've never fastened a seatbelt. Well, for anyone in this room who hasn't seen the Pokémon GO phenomenon, it was celebrated, especially starting, I would say, the June, July, August time period of last year. It's a location-aware game with a live map. So here again, you're tracking in between the real world, a real map, real coordinates, real world objects, and a virtual world, which are these lovable, well-known characters by the Pokemon brand. One of the things about this application that I think is so interesting is the tie of in-game content and actions to real-world content and actions. So for many people who have played Pokémon GO, one of the joys is finding interesting buildings, artwork that's public on the street that you might appreciate in a new way, even because you're seeing it for the first time in an application. Even though that same artwork is, or at least was, there for you in the real world to see. And on a mobile device, Pokémon GO provides multimodal, context-sensitive output, everything from visual to haptic. All right, so just to show some basic features, two of the aspects of Pokémon GO that I know we'll talk about today are, one, the interaction with the map. This is a tweet showing a picture of a real-world map that has become a virtual map in the Pokémon world. And there are these characters owned by a variety of rights holders that are traditional Pokémon characters now appearing in this augmented reality context. Why is it augmented reality? We don't show it here, but for people who have played the game, you can have all of the characters appear on a sort of a green screen experience. Or they can appear, here's your camera on your phone, and you are seeing the real world with the Pokemon character overlay. That's why many practitioners, that we can fight about this if people want to fight about it, I would say that Pokemon GO is an augmented reality application.
And if you haven't downloaded the app yet, we obviously encourage you to download the app after our presentation. Actually, I think all of our panelists, we all have downloaded the game and played ourselves, or one of our children plays it. And so it's definitely the most entry-level way to get familiar, and if you've never experienced augmented reality before, it's one of the best entry points.
And there are 2 Pokestops within the hotel.
Yes.
Just in case you need.
The escalators right over there are stops. So, Christy, your company has developed an AR experience in connection with other companies and entities like museums. Can you kind of explain some of that?
Sure. So for those of you who may not be familiar with wargaming, our biggest game is, our flagship game is World of Tanks, and then we're also known, we have World of Warships and World of Warplanes, and what we're known for is militarily historically accurate games. So the tanks in our games, the planes in our games, the ships in our games, we have military historians on staff who keep us honest. Even me as our U.S. General Counsel, that if, God forbid, I mix up a battleship and a destroyer, I make a fool of it. But it's great, and it gives us a really cool opportunity as a company to work with museums, particularly in these digital times that we live in. Museums are really struggling to get these digital natives, as they're known, into their doors and into their experiences. So we've done some really cool stuff in terms of VR and AR to help museums develop experiences to get these younger attendees in the door. So this is an example of something we did with the Royal Air Force Museum in the UK and a company called Red Loop, and we created an AR experience called Apparitions related to our World of Warplanes game. And this allowed players to check out bombers at geofence locations so that even if you couldn't go to the museum, you could still experience the warplanes wherever you were. So we, in effect, brought the museum to them, so which is a really cool thing. And here you can see 2 bombers over Trafalgar Square. So, you know, it's kind of like spawning a Pokemon, but a little more World War II. So, and we'll go to the next. This is, and then this is another example. This is an app that I worked on. We did some licensing, and this was a really cool opportunity with the HMS Caroline. And this experience is available Google Play and the Apple Store. This app tells the history of the ship, her role in battle, and then to the right you can see we also provided iPads, so visitors could check this out on iPads. And next slide. And then this, the other aspect that we provided was our team built a virtual model of the HMS Caroline. And this shows her in her World War I configuration without any changes. She was changed after the war. And so this, this is an example of how we were able to make a museum exhibit more interactive and also but still show a really cool ability of detail that maybe you wouldn't get. Some of these warships that we've done models of, their engine room can be 2 stories high, or if it's a tank, if you go to a museum, they're not going to let you in the tank, unfortunately. Like I said, I literally deal with almost any question about what you can do with the tank. So yeah, when you're at a museum, access can be a big deal for licensing, for filming these type of things. So that's another whole talk. And then this is another app that we've worked on for as you may not know, it was recently the 100th anniversary of the tank. So we, of course, were involved with that, and we worked with a company called Ballista Digital to develop the Tank 100 app. So it showed the history of the tank and 360 videos of the interior of various tanks, including Mark IV, and also an AR experience where you could spawn a tank wherever you are. So kind of like a Pikachu, but a little more serious. Our players are very serious, and they really love their military history. So it's a great opportunity for them to experience what it's like to be in a tank, what it's like to fire ordnances from inside a tank, and so really cool opportunity. So just wanted to show those.
And Chrissy, is there a cost to these apps? Are they free or mixed?
These are free, yeah.
That wasn't planned, I really was curious. I want to ask.
Yeah, well, we are a leader in the free-to-play market, so we want to have a good opportunity for people to come in and play our games.
Great. So yeah, let's go ahead and dive deeper into the legal issues, and let's start with some key provisions and clauses that are used in an effort to remove or defer liability away from companies that are developing games with augmented reality features. Chrissy, we'll go back to you, and let's look at some of the agreements that you encountered.
Sure, and these, in gaming, you run into these a lot, and it's interesting that, I think maybe in the early days of the internet and computers, these seem kind of arcane, but it's amazing how ubiquitous these contracts have become in our daily lives. If you use Facebook, or if you use any social media platform, or if you play games, these are part of your daily life, like it or not. Whether you read them before you click accept and update your software or not. So you have end user license agreements. These are typically used with downloaded or purchased games and apps. You have your terms of service or terms of use, and these are typically used with web-based content. And then you have your game rules, and these are typically, for us, the things that take the longest, because you can't develop your game rules until you play it and really experience it, so which our legal team is good about. And the game rules interact, and these are all like living documents, and they all kind of live in the same ecosystem. So your game rules will interact with your end user license agreement and your terms of service, and govern player behavior in the game. I do a lot with support, and it's amazing how much we may stand by them even as lawyers and just update our iTunes or whatever, not to pick on anybody. Whatever software needs to be updated, we may not read the update, we may not read whatever changes came into one of these documents, but they still govern, and it's amazing how much our players will dig into these and be like, well, section 9.3 says, this, but, and it's that classic thing that they'll be like, well, it says I can't do this for commercial use, but I formed a nonprofit, and, it's truly amazing, so, but they'll dig into it, so it's good to keep these in mind, because they still govern your activity online.
And Chrissy, I want to touch on something you just said. You mentioned you have to play the games to actually understand as an attorney how you can craft these things. So can you just say briefly your experience in actually overcoming the entry barrier that some attorneys might face if they've never played games before, if they're looking to get clients in this area?
Sure, I would definitely say that if you're looking to get more clients in the game space, get in there and play the games. And when you're interviewing in this industry, one of the biggest questions will be, what are you playing? For us, Pokémon GO was not just a fad. It was an employee handbook issue, because we can't tell our employees. In the case of Volkswagen, they banned Pokémon GO in their facilities because of the ability to take pictures with the augmented reality aspect of it. And for us, we can't tell our team not to play. We're passionate about making games, so for us it was game reasonably. But so. There's definitely some interesting aspects with that.
Yeah, so definitely just try and play the games.
Yeah, so definitely, but yeah, because, game industry attorneys, they're going to want you to be up on their game. They're not going to want to necessarily get billed for you to get up to speed. So but that's great, because if you're passionate about gaming, then that should be part of your parlance anyway. But so walking through terms of service with this, I choose you. As a game manufacturer, you can spell out your choice of law, your forum, your format for handling disputes. As I like to talk with our team, it's kind of an interesting opportunity as a game maker, because, as a game publisher, because we basically get to run our own little fiefdom. We have our rules, we have our laws, and if you break them, we take your tank away, or whatever currency within our game. So you want to spell that out, but then you also have, but not you. So you want to have disclaimers for liability, third-party content, experiences they may have in the game. People can be nasty to each other on the internet, so you want to make sure that you're protecting a client in the game space from any third-party issues. And then also, any of your commercial issues, breaches of warranty, consequential damages, you want to address that. But then also, and this comes up all the time, so who owns that Pokemon? You know, if you've broken rules in a game, you've probably had something taken away, and you're like, you know, if it's a Star Wars game, you're like, hey, that's my lightsaber. You know, you took that away. Well, actually, that's not your lightsaber. You know, that's you were granted a limited. Typically, you were granted a limited license, and part of that is contingent on you obeying the rules of that particular game. So if you violate them, you may, you know, that may get taken away. And so you want to spell that out and be careful if you're representing a games industry client that. You know, that you spell that out as to what content and currency, what rights they have to that, and what rights also is the user granting to the game publisher. Because you know, if your fans are passionate about your game, they're also going to want to create content about your game, and so you want to address that as well. So.
And if you're interested to see what kind of marketplace there is, just do a Google search or go on eBay and look. World of Warcraft is a good example, and just search for items that people are selling, and digital items go for quite a hefty amount of physical or real-world money, if you will.
Yeah, and there's also been the trend and issue of for some games, some publishers have allowed third-party gambling of items within games, and there's been some state enforcement about that. So that's definitely something to look into as well if you're representing clients in this space. And of course, for terms of service, let's not forget we're here for an IP conference, so let's not forget about our copyright and trademark. And again, you want to spell out your ownership, you know, who owns the IP within the game, and your trademarks, and make sure you have all that spelled out. Can also include, you know, your DMCA copyright agent information and contact information, and many other things. You know, certainly, like I said, they're living documents. So, and just like an employee handbook, you know, things happen, and you add to them or you subtract, and you know, so it's definitely like if you have clients come to you and say like, oh, well, I need a, you know, stock. You know, terms of service or end user license agreement. Yeah, you want to be careful because you also see sometimes with it's really cool that people can build an app in their garage over a weekend, but sometimes they'll copy and paste something from a bigger game, and the problem with that is you can be subjecting yourself to much bigger obligations. So you might have a bigger game publisher that's subject to international issues or subject to different data handling requirements that a smaller app developer might not be. So you want to be careful to make sure that it's tailored to how they're actually handling the data and actually doing stuff.
Can I throw in one quick point there? So,
sure.
Terms of service and ULAs have evolved a lot over time in the gaming space and the software application space too, and it's a bit of fun historical spelunking if you have to go and look at older terms of service and compare them to modern ones. I completely subscribe to what Chrissy said about it's not one size fits all. You can't take these terms of service here that are for this giant multinational game that involves, you know, real world parks and property, and put it over here on this, you know, a game that looks like you know, a dual type of game. They don't work, and they've changed as both of the legal landscape has changed, and as we've figured out what people do with games and with IP, you know, because we play the games and understand the industry as both users and practitioners, we see, aha, this is what happens. We want to encourage this kind of behavior over here. We maybe don't like this as much over here, so we'll change our language and type that on what might have been a gray area before. So, just want to throw that in.
Oh, sure, and there's also some fun examples. My favorite example is, and also kind of sad on a level as an attorney, but who works on these things. But there was a software manufacturer that hid in their end user license agreement an offer that they would pay you $1,000 if you sent an email to a certain email that was listed in their end user license agreement, and it took somebody 7 months to find it. And actually send an email. So, you know, kind of sad as an attorney that nobody reads it, but hey, it's there, and somebody finally got their money.
So in addition to using the games and actually playing them, it's also important, I would say, coming from this, when you're drafting these as an attorney, to be involved with your developer teams. I think all of us can talk about the importance or have stories about the importance of being involved with the dev team that you're working with within your company or your client. And so I'm from the classical music world, and we have some streaming apps, and that's where I find the most benefit comes out of being a part of the discussion of whatever the developers are doing, whatever sprints they're working on, that kind of thing. So I'll add that little practical tip in there too. But Kimberly, we've gotten now some great attorney putting down everything, so you can walk us through the next steps and maybe getting user consent for this.
Absolutely. So that we're not picking on anybody's game, we made up a game for you so we can make fun.
Sorry, do you mind moving the microphone down?
Yeah. Can you hear me better now? So we're going to make fun of Foxy, a made-up game. Consent is important here. You know, you've spent all this time crafting terms of use, privacy policies, and user license agreements that, as we've learned, your users are probably not reading. But you know, as outside counsel, I read them, and your court will read them if you're dealing with me, because you're probably trying to argue that you don't have to participate in a class action, or you don't have to participate in a trial in a court because you want to arbitrate. You know, those are often two of the most important clauses in your terms of use, though certainly not the only most important clauses in your terms of use. You want them to be enforceable. So thinking of best practice would be to get consent right away, immediately. The application, so we've styled this as a mobile application for the moment, and right now a lot of AR, as we've already seen, is in some sort of mobile format. You're downloading it on your smartphone, you're downloading it on your tablet, you're interacting with the application in the real world. As soon as you download that application and your user enters it, you should prompt them to consent to the terms of use, the privacy policy in the end user license agreement. I will tell you that the non-legal team within the app company will push back, for conversion rates, or they want to push that consent farther into the application. So as the attorney, this I think is your best practice right away, immediately. If you have an application that is worldwide, and so you're in Europe, I am almost certain that your European counsel will insist that it's not just best practice, but that it's required to have the consent come right away. You have a little bit more flexibility in the United States if your application is only being hosted and played here. But in our economy, that's frankly not really true much these days. Which is to say, though, that if you are, for whatever reason, engaging in that risk management discussion about when can the consent happen, you could conceivably have it come later in the application. You would want it to be very clear, and that's a very tricky decision that you would want to work through. Consent should be clear. We've listed out the privacy policy, the terms of use, and the end user license agreement separately. Some applications will mush them all into one. You consent to the terms of service, you click in, and maybe there's a couple listed in there, and you see the privacy policy broken out. I don't think that's a best practice. I think the best practice is to list them separately, clearly, so that, for me, that's the screen that goes up in front of the judge when I say this particular user consented to the terms of use right there. They had a link, they knew there was a terms of service, and they had to click accept before they could use this application. That's what I would recommend. On the back end of things, you should also be keeping track of who consented, when the consent was received, because that's evidence that you would put in front of the court to show that you obtained the consents that you want, so that all of the terms of use, the privacy policies, and everything else within the court will govern. There's some philosophical debate over how much more specificity you might need to have as we move forward. Do you have to have a particular pop-up that says you understand that you're consenting to waive your right to a jury trial? I don't think we're there yet. I know some European lawyers that think we are there. In our jurisprudence in the United States, the case law hasn't gotten there yet. Chrissy referred to terms of service, privacy policies being ubiquitous. We're lucky. Most of the courts still tend to think that people know. They know that you're consenting to something, and so you'll find a judge that will not require consent, but we are moving in the direction of consent. We are particularly moving in the direction of consent in mobile. So very much recommend a format that looks like that. The interesting question, and it's really, think about how your AR is being used and what kind of technology. We have consoles and shrink wrap, then we've moved to websites and browse wrap. Browse wrap has transitioned more into click wrap, where you actually have to have a click, and that's essentially what this is. That's where mobile's moving. What's going to happen when you don't have something tactilely in front of you, where you have a headset on? And the headset allows you to download and Wi-Fi, and it's an application. So think through those processes and whether or not there's some other consent that might need to be obtained that can't happen because you don't actually have a phone in front of you or a tablet in front of you. One last point, just in terms of consent, it's not just for litigation. The FTC very much is concerned about what kinds of data usage does a consumer understand is happening, and have you provided clear enough consent to the user about what you're doing with data. So we can go to the next slide. Perfect. So if you're updating your privacy policy, the same concept applies, getting an update. We've updated the privacy policy, we've updated our terms of use, because, again, you want to show that that particular document you've received consent for. You might also want to consider whether or not you have a specific image or specific consent to a type of data usage that you care about, or that the FTC might care about. We've talked about how geolocation data is, to use the word ubiquitous with AR. You might want to have a specific acceptance for your user that geolocation data is turned on for them. To pay attention, because the FTC is really looking at consent and users. It's not just the courts.
So when Pokemon GO first launched, it was estimated about 22% of their user population was made up of minors. And actually New York put in a restriction that registered sex offenders on parole were no longer allowed to sign up for the game or other internet-enabled games as a condition of their sentence. Chrissy, can you tell us what is age gating?
Sure. So, and Kimberly touched on the FTC, and they're certainly watching the game space. And one of the big areas they're watching is related to COPA, which is, if you've ever wondered why you have to check that box and put that you're either over the age of 13 or that you have to put your birth date in, that regulation is why. And it governs that you have to get parental consent if you're collecting personally identifiable data from kids under the age of 13. And of course, you have that squishy area from 13 to 18 where they can void a contract. But anyway, the big thing to worry about is if you're targeting, if you have an app or a game that's targeted at kids 13 or under, and it gets squishy too, because there definitely have been enforcements. There definitely have been enforcements against games that are specifically targeted at kids, that are brightly colored or feature cute animals. But then there's also, if you have a website that is likely to attract kids, then that can be an issue too. So where you get age gating is some companies opt to just not allow users under the age of 13, and that's why you get that pop-up that you have to verify your age. And with and there's different mechanisms that websites and companies use to verify verify parental consent for minor users. It's not to say you can't collect their data, but you have to get parental consent. And so there's different ways. You can get an email. There's different vendors that'll do that. And in the case of Pokemon GO, what helped them was if you've played this, if you have kids and you've played Pokemon GO, when you sign up for a trainer account, when your kid signs up for a trainer account, their parent is required, the parent is also required to have a trainer account as well. So you both have to sign up. That said, I know we're all cynics to a certain extent. Kids can fake things, but you do your best as when you're representing a game company or when you're coming up with a game like Pokemon GO or any of these VR, AR apps, that you just want to verify that you have that consent to try to stay in the good graces of the FTC.
Great. And of course, with any huge successful game like Pokemon GO, there were lawsuits that happened, litigation ensued. An example of this related to terms of service was out of Palm Beach County, Florida, where a Florida gamer sued Niantic, alleging the service's terms of service and privacy policy are deceptive and unfair, violating the Florida Deceptive and Unfair Trade Practices Act. And this was filed back in July of 2016. So most of the cases that we're talking about are still ongoing, and there's just not many updates as of this point. Okay, so in regards to trademark law, there is a major issue with whether game developers must obtain permissions from trademark owners when their trademark appears within an augmented reality game. As John mentioned at the beginning, there's artwork, all kinds of buildings and logos that you'll see through the use of augmented reality games. So John, do you want to kind of touch on this?
Sure. Let's start with copyright. So for folks who are interested in the space or might have family members or children who are interested in the space, Pokemon has been around for a long time. One of the things I think is most interesting about the Pokemon GO game is how, if you try to figure out from a rights clearance perspective where the IP starts, you have to go all the way back to some of the earliest copyright registrations held by Pokemon GO, or sorry, Pokemon International Company, a couple of others, Nintendo, and see, starting in 1998, they have registrations going all the way back to 1996. These are playing cards, books, movies, little sculptural items intended for people to play with or use in their house. And as different characters move through different iterations, different images of different characters, I should say, bits of rights can accrue if you keep thinking about, am I using in Pokemon GO, for example, am I using the Pikachu that existed the first time it came out, which might be in that first set of copyrights from 1998? Is that the image that I care about? If so, I can look and say, okay, well, who owned the artwork on that card? Maybe it's registered with the Copyright Office. Once you think you have the image down, then you think about the movement, right? Because there are aspects of the characters we'll talk about later which might be protectable, including how they move, what kind of sounds they make, etc. You might need to start looking at the clearance rights for things like the movies, which might have different rights holders. You might be working in a worldwide context where your characters might have speech in different languages, and you might present text in different languages as associated to an ecosystem of content as there is in the Pokemon universe. You have to look at translation issues. And so it's a bit like a gigantic layer cake where you might see it and start from the top, but you have to really, from a diligence and clearance perspective, look all the way down the stack to say, where do these rights begin, where do they end? How do you put them all together in a way that makes a licensable package? Whether you're trying to create a game like Pokemon GO or Niantic, whether you're trying to license it out for various purposes or work with them for advertising. This is the when you want to start clearing and understanding rights, when you're trying to make a deal, enter into a market. You don't want to do this in a litigation context where you perhaps misappropriated someone's IP that also has this kind of complicated space and say, well, I thought I had a deal with this person over here that might not cover all the aspects of the IP you're concerned about. This also comes up on the enforcement side, because if you're rebooting IP, whether it's cartoon characters, superheroes, whatever it is, in a new space, as the person at the latest in time, you might have certain license rights, but you want to think about, if I have to go to enforcement, if I'm, to take the Foxy example, if Foxy first appeared in a cartoon in 1980, right, does the television right holder from 1980, or does the video game company have to come and do enforcement if there's some misappropriation of that character or some of the artwork? So there are a lot of questions about, in any space, especially where you're translating some older content into a new art form, a new discipline, a new area, how do you approach the research? The answer should be very carefully and with a very good fork. So for Pokemon GO, so far as I know, there are no specific registrations yet. Everything's happening in real time, at least in the United States. For people who register, you cannot see registrations until they actually issue. And so we don't know for sure whether there are any specific Pokemon GO registrations or not. One more second, which is to say, there's artwork, there's movies, images, sounds. There are also, you can register computer software with the Copyright Office, either as a textual work, because it's like a book, or as a multimedia work, depending on the elements of where the IP is held. All right, so on the mark side, I'm sorry, I'm just getting marks. So similarly, large portfolio that spans 20 years. The first U.S. registration for a Pokémon mark is from 1997, and so you've got imaging associated with the cards, with the television show. There was a very popular television show. I think there probably still is. There are marks associated with various branded events over time, with some of the character names. And again, if you're going to use a mark, it may not be enough to say, well, I'm going to find any old mark in the Pokemon space, find the person who's listed on the PTO website as the rights holder and get a license. That may not be good enough. It may matter what class you're in for the mark. You should know, but you don't always know whether that's been signed. And as anyone who's a trademark practitioner in the room knows, just seeing what's at the PTO website is the beginning, but it's certainly not the end. Again, you want to, if you're entering into a space where you want to be working with marks, especially marks that have had a long history and exist in multiple ecosystems around the world, start at the beginning, find someone you can negotiate with, and get the assurances to say, I'm going to use this mark in this space, in this context, for this kind of shirt, game, project it during a movie, and make sure you're clearing the rights precisely as you need them. One thing we'll talk about later is to work in the video game space, as in so many spaces where you're working with soft IP, you have to know what it is you're actually intending to do to get the clearances that allow you to do that. So if you start and you think you're going to make a dramatic screenplay about Pokemon, you end the video game, probably the first step is amazing, and second of all, you probably have to start all over on the clearance. Compared to the copyrights, the trademarks for the Pokemon ecosystem have fewer owners, at least for marks that I've done research on. But again, just seeing what registrations exist at the PTO isn't everything. There are several pending marks applications right now for Pokemon GO, which is, makes sense and is exciting. I talked a bit about characters. So character registration doesn't exist in the United States. It's not something that we usually get protected. If you had a picture of a Pokemon and you sent it to the Copyright Office, perhaps you can claim rights as an individual image, but that's not the same as saying, I care about this living character in all its forms. There's been an evolution in the law varies circuit by circuit, but there's been an evolution in the case law about what it means to have a protectable character. And there's a recent case on the Ninth Circuit about the Batmobile, where someone was rebuilding vintage Batmobile cars as they had appeared in some of the original television shows. And the question was, is that a copyright violation? That case is interesting because there was also an expired design patent. So you might think that you're in the clear once there was a design patent that was no longer enforceable. But you'd be wrong, because in this case the court looked and said, the Batmobile has certain durable characteristics, the way that it looks, the way that it interacts with others in the scene, etc. That means that if you are using the Batmobile as the Batmobile, it's protected, if I can say, in the penumbras and emanations of the copyrights from the various cartoons, movies, television shows, and other Batmobile-protected IP. This doctrine, at least in the Ninth Circuit, was maybe most famously put out in the Air Pirates case. I don't have a slide from Air Pirates, and if you know the case, you know why I don't have a slide for Air Pirates. But let's just say it was about taking certain famous lovable Disney characters and putting them in very unlovable and adult situations. And so that case was from the 70s. The court came in and essentially started this jurisprudence in the modern era, which said, we're sorry, but you can't make Mickey and his friends do that because they're protectable as characters, even though you're not using Mickey as Mickey from any particular work. I have a trademark up here because I don't know who else has noticed this, but we were talking about it at one point. So Steamboat Willie, who people might know is coming out of copyright protection soon, the original appearance of Mickey Mouse. Steamboat Willie will soon not be protected by copyright in the United States in that original instantiation only. So instead, now he appears as a mark at the beginning of certain Disney shows. And this is one of a number of trademark registrations for Mickey Mouse as a branding device for here is Mickey. This is associated with Disney and a certain line of Disney movies. Genius, absolute genius. But what I mean to say is, even if character protection for copyright might be expiring, don't think you're in the clear, there's other claims that it might have to do. I'm going to talk a little bit about maps. So one piece of IP is going to be essential in any AR game that is location aware is something about the location. And it turns out, sometimes I have a slide with map data and all the providers, and it changes so often, and frankly, it shrinks so often that I think it's easier to talk in the abstract and say, when you're thinking about a location-aware game or a game where you're interacting with locations, you have a couple of different thoughts. There are not that many vendors, providers of map data, and there are some commercial ones, and there's one open source one called OpenStreetMap. But if you wanted to license, so bare bones, you're starting out and you want to get map IP into a game, an application, an educational situation. Look there, you might look at, people used to talk about NavTech, which is now here. There's TomTom. Really a small number of players in the pure map space that aren't bundled with an API. And that's not, for example, platform or phone specific. For people who've used applications that have satellite imagery, that's a separate stream of licensing data. And so you can get some licensing from maybe 3 or 4 different sources, but if you want comprehensive satellite imagery, you can get stuff from the United States Geographic Survey and from NASA, like certain data, and the usage is actually pretty good, but it probably is not going to get you the same kind of detail that you might want for recreating a worldwide historic battle, for example. And so there are companies like DigitalGlobe and iCube that actually will vend you satellite data in its sort of purest form and give you the most control. Most folks don't do that, right? So there are mapping APIs. Some of them are platform specific, either for iOS or for Android. Some of them are not. Mapbox to Carta. And again, when you're thinking about how to bring map data into your game, think about how much control you need. Are you going to live with it so that you can't have a lot of fine control over the map and however the platform bends it to your line with it? Or do you need the raw data, the geo-coordinate information, etc.? That'll help you know where to license this.
And with Pokémon GO, I think it's kind of important to also mention that Niantic has strong ties to Google, and so that is why Google Maps is very integrated into Pokémon GO.
Yeah.
So their map data is very accurate.
Yes.
To say the least.
But so far as my understanding is it's a separate company, which means there's some kind of license there for the Google Map data. Your mileage may vary about whether you can get the same for that map data.
And we also wanted to touch on, some of the licensing aspects for this. So, if you're licensing content for a VR or AR thing, you want to, first of all, definitions are super important. We're lawyers. I like my definitions. Nothing drives me crazier than where there's a defined term and I have to dig to find it. I like them defined up front. But you want to define the content. What are you licensing? For us, if we're licensing, tank models or ship models, that's one thing. But are we licensing beyond that? Are we licensing? And if you're in the game space, are you licensing a single title? There's certainly publishers that have just one title that is their flagship, or you may have a full franchise of things. So you want to be sure. These days, you really want to be careful as to what you're licensing and how you define it. And there's, definitely, as John mentioned, different licensing among the Pokemon and Pokemon GO IP holders. If you're licensing from third parties, you want to look at some of that stuff.
And on the game engine side, right, it's kind of like the map space. There's a little more of an open universe on game engines, but there are really a couple of big players. And think about whether, it's great to get something fully featured, but it may or may not work for you. Choose carefully as you decide what your game engine will be. Kind of in for 1 second, because I think the fascinating point is, we talked about how there's a map license, we believe, from Google to Niantic. Similarly, there's almost certainly some licenses from the historical IP holders of the Pokemon franchise. But if you've played the game, you'll note that there are these things called Pokestops and gyms that might have an image of something, whether it's a sculpture or a building. When Niantic was taking submissions for an earlier game about where to make these, they encouraged people to nominate, I think they call them local gems, things that were important. Oh, I'm sorry, thank you. Can you hear me now?
Yes.
Great. So when Niantic in an earlier game was taking submissions for what might be a Pokestop or a gym, they encouraged people to nominate local gems in their communities. Some of those came in. For instance, there's some lovely restaurants where I live in the East Bay in California. And some of those stops might include pictures of a mark of a restaurant. Did Niantic go and license all of the marks from all the places that show up in Pokestops? We'll talk a little bit more later, but Probably not. And so, which probably is reasonable in the circumstances. I bring it up just to say, sometimes an important part of your licensing discussion is decide what you're not going to license, because in a game that is meant to span the real world, you can't possibly get rights from everybody, or it seems very unlikely. It seems like it would be a big expenditure of resources. And so part of your licensing model is going to be decide where you're going to take some tolerance for unlicensed content. And your engineers and the art folks are tending more reasonable. The engineers are going to push that. So for people who work with development teams thinking about where the license is, you'll hear all of the tropes, right? Well, it's fair use because of this or that, the other thing. I guess I took this music that's less than 30 seconds and I changed the end so it's fine, right? Push back, use your lawyerly skills, and try to make sure that when you're making a decision about what to license and not to license, it's based on what the law actually is and not what the engineers wish that it were.
But I read a blog post that said I can do that.
Exactly.
There's a link. I mean, come on. You definitely want to do that. And this is my mini ethics rant here. I think a big thing in this space and just in anything as a lawyer with IP is really, you've got to understand if you're licensing a client's content or if you're in-house counsel and you're looking at a license, you've really got to understand how that IP is going to be used. And a prime example of this in the litigation over the game Band Hero, no doubt sued Activision in part because they had licensed their avatars and their music to be used in the game, and then it turned out that you could unlock their avatars at a certain level and make Gwen Stefani sing in a man's voice, and they famously said, we're Rolling Stones fans, but we really don't like Gwen singing Honky Tonk Woman, Honky Tonk Woman as a man. And Activision came back in their answer, and it's a really good ethics practice point, that Activision came back and said, you had very experienced representation help you negotiate this deal, and this is a well-known feature that you can unlock certain features in games. And so basically the gist of that is, you had counsel help you, and they should have known what games can do. So if you don't understand a technology that you're potentially licensing something for, either get up on that technology or find a teenager. Seriously. Find a college kid, find a teenager, find somebody that can help you understand the technology. One of the best tips I got last year at a conference was, if you're in the game space and you're involved in litigation, the best thing you can do is get your game and potentially the console in front of the judge or the judge's clerk as soon as you can, because if they don't play it, if they don't experience it, they may not understand it as much as you want. And in the tech space, that's critical, as my colleagues up here who do litigation can tell you. So. And then also you want to define your deliverable, just on this last point. What's the end game? What is the end product going to be? And that goes back to my ethics point. So.
Right. A simple example is you've licensed in the IP for your game, your media app. What about if you decide to do online documentation? Is your IP license cover documentation? Does it cover testing? Does it cover media packs that you give out at conferences? So again, to clear rights, to make sure you have the right license, you have to know what it is that you're going to do in somewhat excruciating detail to make sure your clearance covers all your corner cases.
John, you touched earlier on the early iterations or the predecessor to what became Pokemon GO and the early gyms and stops. So can you talk about sponsorship programs, and Julie, you can also chime in. I know you have some experience in this area too.
Sure. So there was a lot of excitement about Pokemon GO in many communities around the world, and people wanted to get in the bandwagon for a fairly substantial period of time. People knew that a sponsorship platform for Pokemon GO was coming. And that was great, because I don't advise anyone to, on his or her own, go through the thicket of trademark, copyright, and other IP rights that are associated with this ecosystem. So getting a license from someone who's represented to you, and warrants that, yes, you can use this IP in this advertising context is great. But people didn't wait, and so you got Pokemon images popping up all over the place in different contexts. That's kind of that's more of, I don't know if that's sponsorship so much as, we'll say, a celebration of a popular game. But if you are a large company like McDonald's in Japan or Starbucks in the United States, you are better off waiting for a formal program so you can define the metes and bounds of what you're allowed to do formally and rigorously.
Right, and just to kind of echo that, and I think you touched on it the other way in the previous slide of user-generated Pokestops and gyms. And if you're going to have that model, you really have to think through the consequences. You're almost inviting users to use the Pokemon brand to their benefit as well. I know on Facebook campus there are, I think, like 13 Pokestops and 3 or 4 gyms, and often you see people posting things related to Pokemon to draw attention or traffic to some of those areas on campus. So that's something definitely that people who, or as you advise clients creating these apps, that it's something that you should keep in mind.
And just a tiny teaser issue here. Some stores, for instance, in my neighborhood, would do things like if you showed a picture of a Pokemon you found in the store, give you a discount. Or maybe you've been into a lottery, everyone who is a gym leader in this hour, someone gets a free copy. There's, I'll maybe refer to you on this, but there's a long list of sweepstakes and contests and giveaway laws that might come into play if you, as the game developer, are interested in inciting that kind of behavior, or if you, as the storekeeper, decide to do that. So that's probably another talk, but just so you know, once you start, raffling things off, giving things away, then there's a whole different set of laws that come into play.
And I know that there are some bars or taverns that were on the other side of it, not too happy to have all these young players coming and not either being under the age of 21 or just sitting, ordering a drink, and just sitting there for hours. So there are two sides of that for business owners as well.
Yeah, or they just weren't aware in some instances. I know there was a bar in my neighborhood that I went by because it was a Pokemon gym, and it's a good place too. But definitely that I was like, this is a Pokemon gym, and they were like, no, we had no idea. I was like, we better get on that. Maybe give them a discount.
So Jimmy, can you tell us how architectural works and the protections of them fall within the scope of this?
Right. So Section 128 allows an exception to copyright ownership for architectural works visible from a public place. But there are sculptural works, statues, murals, paintings that appear within the game as pictures, and that really raises issues as to whether there's infringement. Pokestops and gyms, they use images, and they could potentially depict works of art, and those might not be safe from a challenge from the owner of the copyright, even if the works are associated with publicly visible buildings. What's interesting is that I think how the DMCA safe harbor comes into play. I think and Pokemon Niantic may have thought through this because there's the request button on their website, including the option to report an issue with the gym or Pokestop. So, but it's definitely an issue that they've thought of and an issue with the app.
And what about the other areas of the Copyright Law or Copyright Act, such as VARA? How does that play in?
Right. So VARA is if we digitally alter art, the question is, could we be liable for violating the artist's moral rights? So VARA is what I call the federal moral rights law. It grants artists, among other things, the right to prevent distortion, mutilation, or modification of their works that would prejudice the author's honor or reputation. I'm not sure if this really comes into play in the AR space, but and this image is tilted art, which I think kind of led to VARA, if I'm not mistaken. I think the government took it down, and there was a little uproar from that, which I think led to VARA. But I'm not sure, but it's definitely an issue to think about as we get into AR.
So the question is, if you put a Pokemon on top of this artwork, have you defaced it in some way?
Yes. I'm a little skeptical, but it's definitely a question that we should consider.
And in thinking about this, one of the things that occurred to me was, John, you kind of alluded to this at the beginning when you were talking about augmented reality and how it's growing. And right now, there's not much in terms of the technology behind the process, being able to recognize real-world objects, such as like this is a table or this is a piece of art. And so in that sense, once we maybe get to that level of technology existing, there might be a way for somebody to publicly deface something or leave it there, and that data is stored so that when other users come by and they see it, that's kind of what I was thinking might be how this applies in the future, because you never know what the next game developer is going to come up with. So
I definitely violate. If this is a violation, I've definitely violated on multiple occasions.
For people who practice or have connection to practice in Europe, the moral rights arguments are much stronger there, and the laws are much stronger there. And one interesting question for me is, there's a right to withdraw artwork and other works of that sort under certain continental law. France, for example. Many Pokestops are the pictures of artwork as it was displayed 8 months ago, a year ago, 2 years ago, that might not be in circulation anymore. As the virtual set of artwork on the street starts to drift from the actual set of artwork on the street, does that create issues at least under European law? I think it's an interesting question, and I don't know that it's been brought up in an adverse context, but I think it's worth thinking about whether you need to account for drift between when you capture the world and as the world itself evolves.
One hypothetical scenario where this might actually become controversial is, let's say the overlay is kind of offensive, and we have a lot of technology where you can, although we think of Pokemon GO as kind of fleeting and temporary, but oftentimes you can capture that and then you post it to social media, and there's a lot of uproar over whatever is captured, even though at the time we thought it was temporary. But if it somehow becomes permanent and circulated, I think people may raise a better issue. So it's I know I was skeptical, but there are definitely scenarios where I'm sure people would contemplate raising better to protect their own.
And when Pokemon GO first came out, speaking of it, it was common for a lot of people to be posting pictures of themselves posing with their character that they're about to capture. They would hand their phone to their friends, and then they would just screenshot the augmented reality image being placed next to them in the real world. And so that's a prime example that you just mentioned. So Jimmy, you touched on the request button to have things taken down, but let's go kind of expand on that further, Jonathan. What will be the actual enforcement options?
Sure. So one of the questions that I alluded to earlier, so I think we can dispose of this slide pretty quickly, once you actually have a situation that you might want to take an enforcement action, if you're the rights holder, either the original rights holder or as the licensee who holds the game, how do you actually enforce? And what are the circumstances where you may or may not want to do that? There's a lot of, you want your game ecospace to be pretty vibrant, and I think a lot of game companies are sensitive to the fact that certain kinds of enforcement actions get a lot of support from certainly from the company and from the game community. Some might not, and that's always sort of an initial issue. There are often jurisdictional considerations. Sometimes it's really tough to say, if I am here and this image is posted on this website over there, and our server is in this third country over here, where do I bring the lawsuit exactly? One thing that often happens in this space is you'll do a lot of cease and desist work rather than, in advance of it, hopefully, rather than bringing in legal action. And there have, in the Pokemon space, there was a set of third-party mapping applications. So for those who played the game, there were some original features about how close by you were certain Pokemon. And then that was disabled for a reason that there's a lot of speculation in the community, but we can't say why for sure. And so a number of third-party companies came in, sort of made use of an API that perhaps Niantic didn't want to serve as a public API for the world, and would all of a sudden you could find where Pokemon were spawning in real time. You could, instead of having to wander around the city of San Francisco, you could say, well, look, at 3 o'clock there's going to be this great Pokemon over here. Let's just go there. So Niantic did send cease and desist letters to a number of those companies saying, we're super happy you like the game, and maybe you shouldn't do this. And sometimes the letters are worded a little more strongly, and there was some backlash from the user community about taking those features down. I think it's an interesting real-time study because the game was very, very popular, and there was a feature that users really wanted, and it wasn't for a period of time available at all through Niantic. And so when innovation steps into the gap, that can be great in a game context if someone expands on your work and makes it into something new. But going back to what Chrissy was saying earlier, we always have these rules, right? The rules of the game, the terms of service, the EULA, and those are your tools for enforcement. If you're thinking about somebody who wants to step into that space, I want to add this feature to Pokémon GO because I think it's cool and it's missing. Better to work, if not in partnership, then at least with full regard for the limitations that are out there under the law and sort of in the terms of specific agreements that matter.
Yeah, and that's a great point, John, because that is something I wanted to touch on, that you have a unique aspect. We are here at an IP law conference, but you have a unique aspect, and I think you're seeing this expand to more traditional media companies, but I think particularly in the game space, you have to always think about your user experience too. One of the metrics I'm evaluated on is player happiness in my job. And so I'm always thinking about, on one hand we have IP that we want to enforce, but on the other hand we want to keep our players happy. So we keep a certain amount of IP that we provide as fan kits so that players can make user-generated content because they're passionate about our games and we want them to be engaged. So you have to toe that line, and also I think given the expansion of social media and the internet, I think lawyers are a lot more aware of how a cease and desist letter might be perceived. We've certainly seen some of the, where somebody's kind of maybe bungled an attempt to send a cease and desist and it's gone viral, and you don't want to be that. You don't necessarily want to be that person, or maybe you do, to make a point. But so.
And understand who the target of the cease and desist letter is too. It can very much in your user community depend on who you are sending that letter to and how it's received.
Right.
So I'm not sure that all the panelists will agree, but I actually think that TTAB proceedings create less bad press and user community feel because both because they're harder to find out about, and also because at least many of the people active in the game community, often the TTAB actions are taken against folks who are egregiously trying to free ride on remarks. And so for people thinking about whether a cease and desist action makes sense, if your tolerance is concerned, if you're worried about the reaction to that kind of enforcement, it's still important to monitor the filings of PTO and really be on top of marks that you may want to oppose. And at least in my experience, that tends to be less controversial. Let's leave it there.
So John, first of all, can you tell us why you're rickrolling the audience? And then second, can you tell us about AR-based advertisements?
Yeah, so I thought I'd spare everybody the music. But let's just say that there were an application that let you put Never Gonna Give You Up and an image of Rick Astley wherever you wanted, on top of cakes, on top of walls, or that you could, for instance, hijack someone else's VR experience and make this happen. That might be pretty entertaining. Perhaps it's less entertaining if you can create an application that someone might use. So think of think of an application that lets you translate street signs and billboards right in real time. And maybe that also includes pop-ups for advertisements. And maybe it includes pop-ups so that coffee company number 1's mark appears whenever you see a picture of the logo of coffee company number 2, or a video game or restaurant or whatever you might think of that has a long and storied rivalry. That might be more of a problem. So if we think about, this hasn't come up in the wild that I know of in the legal space, but we can go back to the principles that are reasonably well established. If I see coffee company number 1, and I say, I want to put up advertisements whenever I see this in my augmented reality application, is that like a keyword search auction? Are you auctioning off the rights for keyword 1 that happens to be the name of your competitor? If that were the only law that applied, well, sometimes that could be okay, right? The question is likelihood of confusion and whether you're acting deceptively and a couple of other constraints. I think it's tougher in the augmented reality space because it's so much more in your face, right? A lot of the cases about the keyword sales look and say, go into detail into what the advertisement is and say, can you figure out that this is meant, to not be connected to company 1? And it's hard to do that when you can say, look, this ad pops up only when I'm 5 feet away from the store for company number 1. I think that feels more a stronger tie rather than just a keyword sale. The same thing on location search. Let's say you don't do it at all based on recognizing the logo, which by the way is computationally hard. And instead you say, here's a map, a geomap of these points of interest where I want these marks to show up, and I want to sell advertising based on where you are in the world. Again, you might create a problem where if you are selling, here's the set of, here are all the vending machines that sell soda product number 1 from a certain distributor, and I'm going to show the mark for soda product number 2 whenever you get close to one of those vending machines. That again starts to feel like a problem. So we're at the beginning of understanding how this law is going to work, but there are apps already that you can go and walk around the world and see pop up, your own personal set of billboards in case you decide you don't like looking at buildings and people and monuments here in DC. I can talk to you afterwards and show you some of these applications that will fill your world with billboards instead. And that might be a fun way to think about some of the advertising implications.
It's kind of another way to think about the Back to the Future moment where Michael J. Fox is almost eaten by a digital shark. Kind of similar to that, in just a different AR perspective. So Kimberly, can you kind of take us home here with a bundle of other issues that relate to augmented reality?
Yeah, and we've touched on a lot of these, and so in the interest of time, I'm going to keep it short. Franklin, you're going to talk a moment about several cases in the tort space, and that they come up in personal injury, trespass, attractive nuisance. I think the real question here is going to be on the AR side of the application piece. What are you doing? We talked about opt-outs to allow locations, for instance, to opt out of being a location. There's litigation on that issue now. Museums have not wanted to be a stop. Individuals do not want people coming to their homes, and so there's litigation about that. I think there's also going to be an interesting slate of litigation about if you have an augmented reality glass. I think this is where it's really a Google Glass or something like that, where it's affecting your movement. I've seen technology for flying planes or driving cars. It's providing additional information. How is that going to play into the tort context? I think we're going to come back to the principles of terms of use are really right now going to be the things that are going to most protect companies in the tort space. What can you and can't you do? You cannot drive a car while doing X, for instance. Trade secrets we haven't talked about today, and I wanted to spend a little bit more time there. This space is developing, the market is developing, where the technology is going is developing. We've heard about a number of different joint partnerships in the augmented reality space, which is to say that it is ripe for a whole host of trade secret misappropriation cases. What you're sharing, your joint development agreements with your partners and confidentiality provisions, people moving from company to company. So thinking about what is your trade secret compliance program, identifying your trade secrets, and not just saying, well, I have an employee invention assignment agreement that has a paragraph that says it's confidential. I'm good, you're not good. And so really thinking in this space about trade secrets a lot more concretely than you might in other technology areas. Rights and publicity we've already touched on. Really, I think where we're going to see litigation there is in the avatar space. It'll be really interesting when someone comes up with a business model of selling avatars that look like real people or real things, and the litigation that's going to spawn from that. Consumer class actions, and I want to touch a little bit more on data. Data in the augmented reality space is an intellectual property right that is being sold, and business is being done about the data. Do your consumers know that? What have you told them about what you're doing with their data? What are you doing to protect their data? Have you done a cybersecurity audit of the technology, and are you really doing what's necessary to protect the data? We should expect to see a fair amount of litigation over that just because hacks happen and data is sold. Also in the joint partnership context in the consumer class action space, pay a lot of attention if you're doing any sort of direct marketing, the TCPA, CAN-SPAM, there's a California version of CAN-SPAM, which is email, direct marketing. If you're getting email addresses from your partner and you're the one that's using them, do you have the right to do that? Are you behaving appropriately? More concerning is if someone's doing it for you and you have this conglomerate of brands that are working together for a particular piece of technology, what rights do you have in those phone numbers, in those email addresses, and what's being done? Because you may end up in that litigation about the consumer class action. Crimes. There have been allegations of sexual harassment in virtual reality and not gentle accusations of sexual harassment in virtual reality. Who's responsible for that? What prosecutors might do and what the police might do and whether it will be considered a crime is one thing, but whether you've somehow facilitated or allowed, if you're aware of these kinds of activities happening in this space and you have the technological ability to stop it and have it, what's the liability and the responsibility there? Think about that. And then, Chrissy, you've touched on the employment pieces there, employee handbooks. Circling back to torts, I have concerns about, someone driving a forklift, for instance, and doing something with augmented reality. You can certainly see the plaintiff's lawsuit against the company because the forklift driver was using the AR, but what other employment context, litigation is going to come out of this?
Yeah, and going back to that's a great point, and going back to the crime piece, going beyond Pokemon GO, there was a game, I don't wish this game any ill things, but just on things that are coming, there was a game announced at South by Southwest called Snatch, and it's slated to roll out in New York City, and it's like Pokemon GO, but instead of catching Pikachus and Snorlaxes, you can find packages that have cash value or travel trips or all kinds of things. And part of the game is, though, that other players can come and snatch them from you unless you have an invisibility cloak or whatever other things that, and there's your monetization piece, by the way. But I can already see some of the potential issues with players finding each other and snatching things and potentially punching each other in the real world over virtual items. So we'll see. That's, like I said, slated to roll out soon in New York. So I think there's definitely some interesting real world consequences to some of these issues and that you have to think about. Because Pokemon GO, I think somebody walked off a cliff and unfortunately died playing the game. There's all kinds of things when we're all looking at our phone with these immersive things that we have to think about.
As Kimberly mentioned, there have been some lawsuits in this area. Two of the earlier ones filed have since been consolidated together. So this one, Martyr v. Niantic, is often incorrectly heralded as the first Pokemon GO lawsuit, but Martyr, a New Jersey resident, complains that a Pokemon in his backyard caused too much of an issue and uninvited people were constantly coming by his house. So in this case, there are over 50 documented entries, motions to dismiss. So it's just important to remember with this string of cases that it's a reminder about the agreements that are in place between the parties. Because if you'll notice, if you look at the dockets, you'll notice it's not just Niantic that is tied to these lawsuits. It's also the Pokemon company that is named in the majority of these. So everyone is going to get sued. And then another lawsuit is Schaefer v. Niantic. And this one actually comes to us from Canada. A woman in Torrington, Alberta, filed a class action lawsuit against Niantic, alleging that more than 100 people have been trespassing on her property since the game's launch. When there are actually fewer, the interesting aspect of this, so there are actually fewer than 200 residents in her area. So the suit also makes claims of property damage in the city of Edmonton, Alberta. So I think I looked at the docket, and there's not been any movement on that recently. So we do have 3 minutes for questions. We have all of our contact information provided, and this is also in the conference slide deck. So we apologize, the conference slide deck that's in your materials that you were given is not updated to reflect the slides that we went over today. So we're all happy to provide those to you if you want to just shoot us an email or reach out to us in some way. But yeah, we have a brief couple minutes for questions. There are any of their microphones right there if you'd like to ask a question. We covered everything, it seems like. Yes. Oh, we have a question.
Yeah, I'll fight an early morning question. Well, first of all, thank you to the panel for great content. This was really informative so early in the morning. My question is, it has to do with the fact that I think it's clear from the discussion this morning that technology in the space is really rapidly evolving and very talented development teams that you have to work with. And I think Franklin made the point that it's important to become sort of embedded with the development team as you go on. However, you also made it clear that in spots like getting consent or other things that they run on blog posts, that you're going to get a lot of pushback from the development team. So I'm wondering, what are some best practices for sort of throwing that line of being able to work closely with the development team, but then also not being seen as like a overly strict parent that eventually is going to be cut out of the loop because you're saying a lot of things that are really cool and interesting in what the development team wants to do with the technology?
I can touch on that, and then Chrissy, I know you probably have some. But, so with my development team in particular, they're based mostly, the leader was out of Germany, and so the best discussions happened obviously when they came to our US office, and I was able to talk with the product manager and actually go through the workflows that they were developing. But beyond that, it really is an ongoing struggle at a small company like myself. It does not focus on any type of development of games or services. So it's just constantly making yourself a part of that conversation, checking in, hanging out, getting coffee where they are. That's kind of from a non-solely game development company. And Chrissy, you obviously have a much better perspective.
Yeah, and I'm sure Jimmy can touch on this as well. My biggest thing is, my motto being in-house is that I really try to not be the department of no. When you say no and you're constantly a barrier, then things go wrong. That's when they stop, when your tech team feels like you're just going to kill their project all the time, that's when they stop coming to ask you questions, and that's when things can really go wrong. And I really go out of my way to try, of course, I want to protect our company, of course, and our interests, but at the same time, we have to get products out, we have to keep our players happy. So if I say no all the time and my team doesn't come and ask me, on a very few occasions where I've had to, kill a project, it's because somebody, didn't ask first. So, and then they always ask after that. So it's a constant educational process too. It's a lot of what you do is educating. I think we all, as lawyers, that a lot of what you do with clients, internal or external, is educating about the law and options and saying, okay, maybe we can't do this, but let's try this. Trying to find solutions. So.
Well, from the outside counsel point of view, I usually start with the spectrum. Here's what I want you to do from minimizing risk as much as possible. And here's the outside edge that I'm most comfortable with, and then let's talk about your options. And I usually have options for how we're going to satisfy whatever the issue is. Terms of use in a international game, you're not going to have a terms of use that's been localized for every single country in the world. So you're not going to do it. So where are your gamers? Where is most of your revenue coming from? Talking through that and coming up with an acceptable risk spectrum for the company, and then coming up with options that everybody's comfortable there, so that you're not, no, you can't do that, you have to have 200 plus terms of use. That's my position.
I think one tip that at Oculus we like to, we're embedded with the client and we get it very early on these meetings with the developers, and I think getting in early and advising them early actually removes a lot of the friction you get later on, because instead of saying no or you need to make a substantive change right before rollout, you get in early and they already they're informed of the risks and they build that into their plan. So we make an effort to attend all these engineering meetings and early on, and it's been very successful for me at least so far.
know the business, know the product, play the game. That all helps you have credibility for the tough discussions.
And if you are trying to build credibility, a good point to know is October is National Cybersecurity Awareness Month, and that's a great way if you're outside counsel to present that to your clients and say, hey, do you want us to come and do a presentation on this? And then internally, myself, I just had my interns over the summer in July prepare all the materials, and Microsoft has great free resources for this. And so that is a great way to start discussion points. And I actually, you can show movies if you can get the license for them, like war games or something like that, that kind of start these discussions and get you embedded. As Jimmy said, it's important to get embedded.
Yeah, and just real quick, and then we'll wrap up. But there's also a really adorable cybersecurity campaign going on right now with Garfield. So I have a Garfield cybersecurity calendar in my office, and for January it was like, I don't like sweat or cyber bullets. So it's really cute. So if you're a parent and worried about cybersecurity, also check that out. There's all kinds of cool resources for teachers and stuff. Anyway.
Well, thank you again to the panelists. We appreciate your time, and thank you for attending.